I'm going to be presenting, I'm going to take you to a tour d'horizon of the topic, but I'm going to do that provocatively, taking my own take on the question of whether visas for asylum should be understood to constitute an obligation under EU law. So I'm going to be speaking about, I thought it would have been a bit more visible, but so I'm going to be discussing a little bit the background of the discussion, so where are we coming from and where are we heading, if that's foreseeable. And then I'm going to contest the approach of the General Court in the case of X and X, and I'm going to be doing that in 4 steps. The applicability issue, so the applicability of EU law, which was denied by the court in that particular case. The impact of the Charter as primary law. The issue of EU competence and the presence of sufficient legal basis in the TFEU as it currently stands. Possible policy options. I don't want to preempt the discussion on this. I know that there are several speakers after me who have different views on this, so I'll just go very briefly through different big brush sort of options implicating different levels of harmonization and centralization from the EU perspective. And finally, some conclusions at the end. So the background, starting in 2002, so really right after the Tampere conclusions and the Treaty of Amsterdam, the European Commission commissioned a study on PEPS. PEPS is the acronym of Protected Entry Procedures, which are supposedly mechanisms that are articulated from member states, facilitating regular and safe access for the purposes of seeking asylum within a member state of the European Union. So it facilitates a legal channel to access the territory and the legal procedures within a member state for the purposes of obtaining international protection within that member state. There's been a sustained discussion through the years that PEPS were a good idea, and PEPS as harmonized under the, so at the EU level. So the Green Paper on Asylum opened a discussion with all the stakeholders. Civil society responded that that was something that needed to be explored. The Stockholm programme actually contained a specific call on the European Commission to develop that. And the European Commission sort of responded to that call, but focused squarely on resettlement as one and only of the feasible PEPs. The Task Force Mediterranean in 2013, which was a communication issued right after the Lampedusa mass drownings, where 700 people lost their lives in 2 different incidents that happened like very close to one another. So there, the need for the opening of regular channels was inserted by the European Commission again. But the wording was a bit vague, and they were just saying that this strategy was to be explored, but nothing else. In the communication on an open and secure Europe, again, the tentative language of the European Commission re-emerges. The European Commission says that PEPS could complement resettlement, which was the only of the PEPs where there was sufficient consensus at the European Union member state level. And they said that we could start with the further harmonization of visas for refugees from 2 different perspectives, coming up with a coordinated approach in practice and issuing common guidelines for the issuance of visas for refugees. None of these 2 things were ever developed. So although the European Commission promised to take the lead on those 2 fronts, that never really happened in the end. In the EU agenda on migration, at the peak of the refugee crisis, in inverted commas, the emphasis was instead on increasing border controls to prevent, and this is verbatim from the communication, hazardous journeys across the Mediterranean. So the main point has been, since 2015, to preempt, to contain unwanted flows, regardless of whether these were flows of economic migrants or flows of people in need of international protection. The 2016 Towards a Reform of the Common European Asylum System communication continues in the same line. It says that we should explore ways to promote. So that's even vaguer a language than we saw in previous communications. And that we should explore that to coordinate an approach at the EU level towards humanitarian permits, whatever these might be interpreted to be. The negotiations on the CCV, on the Community Code on Visas, sparked the debate again. And it polarized the political discussions. So on one hand, there was the European Parliament pushing for an understanding that the Articles 25 and related on LTV visas were providing enough a basis to develop asylum visas for refugees. LTV stands for Limited Territorial Validity Visa, granting access under Schengen rules as an exception to the Schengen Borders Code, not to the entirety of the Schengen area, but just to the territory of determined member states, usually only the one issuing the Limited Territorial Validity Visa. The Council was staunchly against this approach. They blocked the trilogue, the negotiations stalled, and in September 2017, the European Parliament decided to withdraw the amendments regarding LTV visas and take a different approach. In the course of 2018, we will hear more on this point. The European Parliament will put together an own initiative legislative report to call on the European Commission to adopt a separate legislative initiative on humanitarian visas for refugees. In the meantime, in 2017, March, the Court of Justice decided in the case of X and X on two very important points. First, that EU law did not create an obligation to make recourse to the LTV visa provisions as a matter of legal duty. And the second point was that the CCV, in their eyes, did not apply altogether. So they denied the complete and utter applicability of EU law to the situation at hand. So what I would like to do is to contest the European Court of Justice approach. In this case, I think it was not correct. I would personally have followed Advocate General Mangozzi's opinion instead. I thought it was quite much better substantiated. And I'm going to be doing that in 4 steps. So I'm going to revisit the issue of the applicability of EU law, and particularly that of the Community Code on Visas. I'll talk about the impact of the Charter, and particularly the right to non-refoulement, Article 19. The competence question, I'll very briefly approach that. And the policy options, as I was saying, I'll also very briefly touch upon that. So on the applicability issue, first, and I'm sorry that I'm running about, but I'm a bit concerned about time. I'm already sort of reaching half of my time horizon. So yeah, on the applicability of the Community Code on Visas, I think we should take the code at first value. So following general rules and treaty interpretation and legal interpretation largely, as the European Court of Justice has accepted in other cases, we should read the wording of provisions following the text, object, purpose, and the context of the particular wording of the provisions at hand. So that's actually what I'm going to be doing. The definition of a visa is contained in Article 2 of the CCV, the Community Code on Visas. It says that this should be considered as an authorization, a pre-authorization for stay or transit into the Schengen zone for up to 90 days in every 6-month period. But this is not akin to a subjective right of entry. It doesn't create an entitlement for the individual to reach the external border of the member states and enter. It just creates a presumption that the journey towards the external border, the physical external border of the member state, should be considered legitimate. The scope of application is determined, I think, in Article 1 of the CCV, where it is said that the conditions and procedures for issuing these kind of visas, the Schengen visas, the short-term travel visas, and the EU law apply to any third country national who must be in possession of a visa when crossing into a member state. And that includes the nationals of all the countries blacklisted in the visa regulation of 2001, which includes all of the refugee-producing countries. So standing by this provision, whether people are on top of a third country national, one in need of protection or one in search for a better future, it doesn't really make any difference. The motives and the intentions of people are a factor to be considered at the merits, or at least admissibility stage. So it's something that is going to determine the examination under Article 21 of the visa application. but I do not think that it should preclude the applicability of the code when examining that application. It would be so as absurd as saying that asylum seekers who are finally excluded from protection under the terms of the Qualification Directive should a priori have been excluded from the scope of application of the Qualification Directive because it was determined after an examination of the merits that they were failed asylum seekers. I hope I'm making sense of myself. You cannot preclude or prejudge a priori a decision on the substance of a claim. And that's why I think that intentions and motives should not be taken to determine the applicability of the entirety of the code. The code applies to any third country national making a face value application for a short-term visa. The criteria that usually are taken into account to make a determination as for whether the visa should be issued coincides with the entry criteria in the Schengen Borders Code. So these are the general entry criteria under EU law for regular entry. And that includes consideration of the intention of the claimant to return by the deadline. But that's only one of the criteria. There are other criteria to consider. And most importantly, there are also exceptions to be borne in mind. So the exceptions in the Community Code on Visas are the same as those contemplated in the Schengen Borders Code itself. So the code in Article 6 says that on account of humanitarian grounds or because of international obligations, presumably including international protection obligations, that may make it necessary for a member state to issue a limited territorial validity visa, ergo to make an exception from the general rule and issue a visa for entry only in its territory. If that's true, then it means that refusals of visas should follow the same rules as refusals of entry under the Schengen Borders Code. So that although the general rule is that when conditions for issuance are not met, visas should be rejected, there is a small clause in Article 25 that says that this is without prejudice to the wording of Article 25, which is the LTV provision. LTVs shall, and that's imperative language, be issued exceptionally, so as an exception to the Article 32 rule, when member states considers it necessary, again, for humanitarian grounds or for reasons of national interest or because of international obligations. So I'm highlighting several words in different colors because if you stick to the exceptionality wording and when member states consider it necessary, you could conclude that there is a margin of appreciation and that the issuance of LTVs are discretionary. And that was actually the line adopted by the Court of Justice implicitly, I suppose. The other approach is to focus on the shall wording and on the because of international obligations wording and put that in the context of the Schengen Borders Code properly, and especially Article 4 of the Schengen Borders Code that says that anything we do in terms of border control has to comply with respect of fundamental rights. So that leads me to my second point. What is the impact of the Charter of Fundamental Rights? I don't know if I have convinced everyone, but my point on point one, my conclusion is that the Community Code on Visas should have been interpreted as being applicable in the particular case of X and X. If that is true, then the Charter plays a role. Conformity with the Charter is both explicitly foreseen in the Schengen Borders Code and the Visa Code, and is constitutionally scheduled. And we have plenty of case law supporting this approach, as well as Article 51 of the Charter itself. So the explicit foreseeing of the applicability of the Charter is established in the preamble to the Community Code on Visas, paragraph 29, that says that the regulation in its entirety, including, paragraph 1, 2, 21, 25, 32, respects fundamental rights and observes the Charter of Fundamental Rights. That could not be different if we stick to the constant jurisprudence of the Court of Justice. In NS, for example, in paragraph 77, we repeat what is a long repeated quote that I think one of the first times this was emerging in a case regarding fundamental rights. It was the Ordre de Barreau francophone in 2007, so before the Lisbon Treaty, and as is post-Lisbon Treaty. Member states must make sure they did not rely on an interpretation of secondary legislation, like the regulation established in the Community Code on Visas, which would be in conflict with fundamental rights, presumably all fundamental rights encompassed in the Charter. The scope of application of the Charter itself is defined in Article 51 of the Charter, to my mind. The Charter is addressed to the EU, institutions, bodies, organs, and the Member States when they are implementing Union law. And we know that acting within the remit of application of a regulation, as the Community Code on Visas, amounts to implementing Union law. They shall therefore, if that is happening, respect, observe, and promote the application of the Charter provisions within the remit of their powers. And why am I insisting on the applicability of the Charter? Also because of the general rule established in the case of Franzen, where, 5 minutes, I think I'm going to make it, where the Code reminds us that situations cannot exist which are covered by EU law, such as situations covered by the Community Code on Visas, without the Charter being applicable. The applicability of EU law entails applicability of the fundamental rights guaranteed by the Charter. And to my mind, that includes the principle of non-refoulement. So if we piece the puzzle together, LTV's consideration as for whether limited territorial validity visas under Article 25 of the Community Code on Visas should apply or not has to take consideration of Article 19 of the Charter, that is the principle of non-refoulement. The principle of non-refoulement sort of penetrates the European Union legal order in different manners. Article 19 of the Charter is only one. It does that at primary law level, but we know that the principle of non-refoulement is a general principle of EU law. We know that since El Ghaffadji, and it's explicitly provided for in secondary legislation, such as Article 4 of the Schengen Borders Code. So it's all-pervading. Basically, you cannot do anything under EU law without respecting the principle of non-refoulement. So I'm just going to jump over the more technical bits and just say that if I am right, it means that contemplating whether to issue an LTV visa or a normal visa, for that matter, has to take into account the implications, the effects of the action under the principle of non-refoulement. And if the result is exposure of the applicant to a real risk of ill treatment, then the member state concerned is prevented from taking whatever action it was contemplated to take. And instead, after Caldararo, this is black and white, avoid the violation of Article 3 ECHR, principle of non-refoulement, from occurring. There is an obligation to adopt positive action to impede the occurrence of a violation of the principle of non-refoulement. Okay, coming very quickly to my competence question. Is there enough power, because this is another point that the court denies, for the EU legislator to adopt a piece of legislation, an instrument, to harmonize what needs to be harmonized so that we end up with humanitarian visas for refugees? And I think the answer is yes. And there are 3 points I wanted to touch upon to substantiate this conclusion. First of all, Article 77, which is that regulating IBM, so the Integrated Border Management System, paragraph 2D says that the EU legislator needs to adopt any measure necessary to establish an IBM system. And that's why visas, interdiction measures, Frontex, and all of that has been adopted. According to Article 67, in the General Provisions chapter preceding the Charter on Visas and Border Controls, there is an indication that the entirety of the area of freedom, security, and justice has to be constructed with respect for fundamental rights, so presumably also the constitution of the IBM system. There is a more specific legal base, to my mind, that would support the action of the EU legislator. According to Article 78(2)(g) of the TFEU, the EU legislator shall adopt, and this is imperative language, measures for a common European asylum system, including those aimed at managing inflows of people applying for protection. So I think there is no escape. Some people would say that might sort of contradict the policy prerogatives in terms of immigration volumes that member states have been recognized in Article 79. But I would deny that because in paragraph 5 of that provision, member states have that right to determine volumes of admission, but only in relation to third country nationals coming with the explicit purpose of seeking work. So if there is no doubt that people are coming for the purpose of applying for international protection, and applying is different from presuming that they deserve or anything like that, so it doesn't prejudge the result of that application, then there is no incompatibility between Articles 78 and 79. What are the policy options? And with this I finish. I've classified them in 3 families, from less to more centralization. So the easiest and quickest and less costly would be to suspend visa requirements for the nationals coming from unsafe countries. There is enough regulation in one of the visa regulations of 2005, for example, that would allow us to do that, to declassify countries from the white list or the black list and play according to the human rights provisions that have been incorporated in Article -1 of the visa regulation of 2001. So that would be one option. That would be of general application, and it would only entail minimum EU coordination. The other option would be to articulate EU asylum certificates or visas, however we want to call them, modeled on the LTV provisions, so following the European Parliament's approach, allowing travel on a case-by-case basis with those certificates or visas issued by the member state consulates individually. That would require EU harmonization, so a bit more of collaboration at EU level. Finally, we could envisage a complete overhaul of the Dublin system and a pumping up of the solidarity scheme and centralize the whole thing and give the power to the EU visa centers or the EEAS delegations to issue EU asylum certificates on a case-by-case basis with validity throughout the European Union. That could be done with the assistance of EASO, soon to become a general EU asylum agency. This requires a bit more of an imagination and more political will, but that's another of the options. I'm coming to my conclusions, and with this I finish. Just so on my 4 points, I have 5 conclusions. The options, I think this has to be quite clear for the European Union legislator, becomes an obligation when non-derogable rights are at stake. So although the LTV visa provision is written in a way that may leave room to doubt as for the imperative strength of the obligation to issue an LTV, that doubt should be removed by putting that provision in the light of the Charter and the principle of non-refoulement. We need to depoliticize asylum seeker rights and make them accessible, actionable, and effective as any other EU right recognized in the Charter. Forget about that these are third country nationals in misery and in need of international protection. They're just humans with rights. Accept that the scope of application of the Charter follows the general scope of application of EU law, and there is no territorial grounding or impediment for that. The EU is not a state, so statal considerations to define the limit of rights should not be applicable. There are currently enough powers and policy options for the EU legislator to take serious action, and I think the floodgate fears are both unsubstantiated and irrelevant, because actually, according to settled case law, administrative difficulties or difficulties of a non-legal consideration should not play a role when designing policies and actions to comply with fundamental rights. So we need to ensure compliance with the Charter in whatever we do, including issuing visas for refugees. Thanks a lot for your attention.